So, ladies and gentlemen, welcome to our first technical session on emerging issues in antitrust enforcement. Dr. Sangeeta Verma, member CCI, is the chair for this session, and Ms. Nisha Podar, editor, CNBC TV 18, is the moderator of the session. So, Nisha has just come in, so I request her to now start the proceedings.
Can you hear me? A very good morning to all of you. And this is going to be a very, very interesting session. I have personally tracked Competition Commission of India since its inception. And I can really easily say that it's become such an emphatic organization or regulatory body. And before taking any decision in any businesses and in corporate India, now the CCI regulations are very well understood, and people take decisions based on how CCI is going to approve or disapprove their actions. So it's become extremely important now, and it's evolved over the years. But now, as new emerging companies and new trends, new age companies are developing, we are also developing the enforcement, the laws, and the regulations along with that when it comes to antitrust. So today we are going to discuss from this panel the antitrust enforcement issues that are emerging now and how to, with the industry mindset also being incorporated, deal with some of those issues, get the global aspects also in place so that we are aligned with the global antitrust laws as well and the learnings from there. So we are going to discuss all those aspects, but to begin, I will definitely want the chair to first address us on this very important aspect. Ma'am.
Thank you very much, Nisha. Thank you very much, Nisha. It was nice to hear you say that competition matters and competition laws are at the forefront of industry today. It has been our endeavor, and I'm glad it has taken place. Chairman Mr. Gupta, Member Mr. Bishnoi, all our distinguished invitees and friends, a very good morning to everybody. Let me welcome you once again. We've been doing it since morning to this iconic event of the CCI to discuss the emerging issues in antitrust enforcement. A very warm welcome to all our distinguished panelists and to Ms. Nisha Poddar, who will guide us through this complex matters and the whole gamut of issues that we will be discussing in the forenoon today. In this session, we have set out to discuss the very complex but extremely interesting emerging issues in antitrust enforcement. I will be leaving the deliberations to our erudite panel, but in the capacity of chair, I would like to share a few of my observations. We have heard in the morning that the CCI has now completed 13 years of its enforcement, and we have recently celebrated our 13th annual day. So yes, we are now in our teens. And during this period, as competition law enforcers, we have tried to foster a public good, that is competition. It is well understood that unrestrained private action can lead to market distortions that break the link between liberalized markets and productivity and innovation gains that these markets are expected to bring. The core mandate of this commission is to prevent such market distortions. It is here that the role of antitrust enforcement becomes crucial. Our ex-post enforcement regime, as most of the people in this hall would be knowing, and this august audience would be aware, is enshrined in Sections 3 and Section 4 of the Act. We have been able to, over time, develop a substantive body of rulings on anti-competitive agreements, as well as unilateral conduct, through these Sections 3 and 4 provisions. Till date, the CCI has intervened to cause market correction in all the important sectors of the economy. Some of these are cement, real estate, pharma, entertainment, coal, and digital markets. Speaking of digital markets, a significant change that all of us have noticed over the last 2.5 years is that the pandemic has caused a behavioral change. It has caused a behavioral shift amongst buyers and businesses to online channels of distribution. Even though the use of online distribution as a matter of intermediation had started much earlier, but the pandemic has really accelerated it. So what has happened is that business users no longer have an option not to use these channels to reach their consumers. At the same time, this technology has led to reliance on a small cohort of technology platforms. Not only users like you and me, businesses in India, be they retailers, hotels, restaurants, app developers, they all today depend on a handful of intermediary platforms to connect with their customers online. Given their control over data and online real estate, platforms are in a unique position to influence consumer choices and also to steer consumer traffic to specific businesses. This unequal bargaining position in conjunction with the intrinsic features of digital platforms raises some serious concerns for competition and contestability. As market regulators, we cannot overlook these challenges that the market power and business practices of such platforms pose to other market participants. Even small actions on their part may marginalize their rivals. These may also distort competition between businesses that depend on them in some connected downstream market. New age platforms have been the focus of our attention over the last few years. The cases handled range across verticals, such as online marketplace platforms, app stores, payment gateways, online travel, food aggregators, and so on. The cases relate to issues such as self-preferencing, leveraging, data privacy, deep discounting, etc. Examining the conduct of these online digital platforms through the enforcement route and addressing the anti-competitive concerns has been challenging at various levels. At the macro level, two issues have been a matter of debate across the globe. The first is whether the existing antitrust legal frameworks are equipped to deal with the conduct of these platforms, or are new enforcement regimes needed? And the second is the enforcement route on itself and by itself sufficient, or is some form of ex-ante regulation needed? Across the world, this has meant a relook at existing competition legislations, and some tweaking of competition laws has taken place in some jurisdictions. In some other jurisdictions, legislations with ex-ante powers to regulate digital markets are either at a proposal stage or at an advanced stage of becoming law. For us also, the emergence of digital markets has brought novel competition issues and concerns. These are new to our understanding and to our assessment frameworks. The sheer scale of transactions and the transparency issues associated with digital markets add to the complexity. But our advantage is that our Act is quite flexible. It allows examination of most of the conducts that may raise a competition issue. To give an example on the abuse of dominant position, the provisions of the Act allow the Commission to look at a range of competition harms. It can look into any conduct or any act of a dominant player that may result in, say, denial of market access or amount to leveraging, etc., giving us a lot of flexibility to examine the conducts in digital market cases. But Section 4, however, as we all know, applies only when an entity is dominant. But many of the platform markets in India have market structures such that under the traditional assessment framework, the entity may not be found to be dominant. These players but do have a significant market power, and their conduct can be quite akin to a unilateral conduct by a dominant player. Moreover, entities with market power often adopt the same practices. So multi-homing between platforms cannot mitigate the concerns of business users. While our law does not provide for collective dominance, it does allow for examination of vertical agreements of entities with market power that have the potential to cause appreciable adverse effect on competition. The Commission has, accordingly, taken up the concerns in e-commerce under the provisions relating to vertical agreements. Some practices followed by these intermediaries may harm business users and may still require scrutiny. I hope we discuss the possible regulatory approaches today to address conduct arising from the market power of these entities. On the challenges related to assessment frameworks in big tech markets, I would say that it is no longer a matter of debate that regulators have to go beyond price-centric parameters and traditional theories of harm. Instead, we have to look at the specificities of each platform. We need to understand the specificities of each platform. And the assessment of harm then should account for factors such as data, quality, choice, privacy, and innovation. But the questions that arise when we try to look at harm on these counts is how easy is it to assess harm on these parameters? Should presumptions be made about certain conduct by dominant firms guide decision-making? Should that guide our decision-making? Is the industry, and there I think there is a great responsibility on industry, it has been mentioned in the morning also, facilitating this kind of assessment by providing data and inputs in unequivocal terms. Do the competition authorities have the skill sets to sniff out these harms? On our part, at the Commission, we are building capabilities in the Commission through our case experiences, market studies, which have been again mentioned in the morning, a proposal to set up a dedicated digital market unit, training programs, and extensive dialogues with competition authorities across the world. But we do look for complete cooperation from industry to be able to take this forward. And as you can see from what I have just said, there seem to be more questions than answers, and I'm hopeful that today's discussion will help us to answer some of these questions with greater clarity. Let me now very briefly touch on the challenges raised to other things like procedural issues. No doubt, we would want the best procedural standards to be followed, but every procedure, we all know, involves time. And in digital markets, given how dynamic they are, loss of time may lead to irreversible harm to competition. So regulators have to balance between procedural fairness and timely correction in digital markets. To overcome delays due to long drawn-out investigations and adjudicatory processes, many countries, as I mentioned earlier, are adopting ex-ante regulations. These are to prescribe rules for digital platforms. The Digital Markets Act in the EU is one such. It seeks to regulate the conduct of big digital market platforms who have achieved the status of a gatekeeper. In India, different government departments are working on regulations for digital players. These include a data protection bill as well as e-commerce rules. Coming to the traditional markets, cartels remain our top priority. There can be nothing more pernicious than the market having competitors who agree not to compete with each other. So we apply the strictest approach towards cartels. We have a very well-established leniency regime to encourage enterprises to cooperate in uncovering cartels. In the last few years, CCI has handled more than 20 leniency cases and awarded reduced penalties to applicant members of cartels. In addition, we have also been initiating cartel investigations suo motu. Another issue relevant to antitrust enforcement is a concern regarding confidentiality. So after a rigorous consultation process, we have recently introduced a comprehensive confidentiality regime. The objective was to establish a robust process for information sharing so that parties can present their cases effectively without compromising the sanctity of their commercially sensitive information. During the celebrations for the Azadi Ka Amrit Mahotsav earlier this week, the Honorable Union Minister for Finance and Corporate Affairs, Srimati Nirmala Sitharamanji, while appreciating CCI's contribution for bursting cartels and regulating mergers, also highlighted that regulators need to understand and meet the challenges of a digitized era, ensuring that they are not left behind when the entire world adapts to greater digitization in the next 25 years. I'm glad that the distinguished panelists today represent varied stakeholder groups, and I'm hopeful that today's discussion on some of the emerging issues in antitrust enforcement will help us brace for times to come. With that, I will hand over to Ms. Poddar to take us through this complex discussion today, and thank you very much.
Thank you, ma'am. Very well encapsulated the entire ecosystem and the challenges we are facing and the new kinds of harms and new kind of market conditions which are really appearing before us in the market, and an ability to understand that and to address those concerns is very important. So I have with me the entire panel with all the insights and the perspective that is required to thrash out these details and come to some sort of solutions for the way forward on which CCI as well as the industry can really work towards. So I'll first, ask Jyoti ma'am to tell us about her experiences, the challenges, the real-life challenges that you are facing, ma'am, right now as the antitrust enforcement is evolving and in new age businesses, how there are certain hurdles that you are facing.
Would you like to introduce the panel?
So
I would request
Nisha,
you to first introduce the panel, either you or Nisha.
Maybe Nisha, can I request you to introduce the panel before we move on to the...
All right, so let me introduce the panel. Of course, Dr. Sangeeta Verma, the member CCI, she's the chair of the session, and Ms. Jyoti Jindkar Behnot, who's the advisor to CCI in enforcement. She's done a lot of work, very senior person. I have interacted with her for so long since the inception. Dr. K.D. Singh, the director at CCI, a very strong hold on the processes, and he will reflect on a lot of aspects which are very, very technical, and we'll get a lot of understanding on that. From the legal side, we have Mr. Ramji Srinivasan, who's a senior advocate at Supreme Court of India. And in the side chat, I have learned a lot from him, and his perspective will add a lot of legal context to how the meeting of CCI as well as the industry really takes place. Manu Chaturvedi, advocate, Delhi High Court, done a lot of work on antitrust and has a lot of perspective on a lot of aspects in real life issues that the companies are facing and going ahead with some of those critical technical aspects as well when it's concerning the CCI aspects. Sanjeev Bikhchandani, I have known for a very long time, founder and executive chairman Info Edge. We can safely say that he's the pioneer when it comes to the new age space in India, the first listed company in this particular space, and now a very, very senior corporate head and a leader, a thought leader in this particular space. Suraj Saharan, who's the co-founder at Delivery. We know that this company had a listing at a time when the markets were really tentative, and the company is still holding above the IPO price, and a very, very well-regarded logistics full bouquet logistics company which has come in the listed space with a lot of focus on new age and technology, which is so required in this particular sector. He will add to a lot of perspective on how the industry is moving and what else is required from the regulatory standpoint to support the growth of the industry as well. And last but not the least, Dr. Rajat Katuria, who is the dean at Shiv Nadar University. I have just got to know him, but he has a lot of thoughts on how globally things are developing and where we can be moving going forward to get the gold standard when it comes to our regulations as well. So I really welcome all the panelists and look forward to a very good discussion. Jyoti ma'am, would you begin with the challenges that you're facing, some of the real life issues in this particular aspect, and then we can reflect further on that.
Thank you so much, Nisha, for introducing the panel. And at the outset, I also thank Honorable Member for her opening remarks and for having set the agenda for the discourse by the panel. So I have been very fortunate to have been associated with the major part of this enforcement journey of CCI, and having observed it very closely, I can safely say that in recent times we have witnessed a paradigm shift in the types of antitrust cases and issues that are coming before us. Increasingly, cases related to new age markets are coming before the Commission. And this, in a way, is very natural, that increasingly more and more economic activity is taking place through digital players. Internet is facilitating that, and a small number of firms have taken a key intermediation platform position across verticals. The distinct characteristics of the digital markets are quite well known now, so I will not spend time mentioning those, and would try to focus my thoughts on the emerging issues in antitrust enforcement, primarily from the enforcer's perspective. So from enforcer's perspective, this phenomena of tectonic shift in markets has posed multifold challenges. Firstly, the complex business structures and models have evolved based on advanced technologies. Diversity and complexity of anti-competitive agreements has increased with use of new arrangements such as hub and spoke model, algorithms, blockchain technology, which is a challenge both for the investigator as well as CCI, because what it prerequisites is a very deep, proactive, sound understanding of the underlying technology, of the product in question, the market, the interplay between various players within the entire ecosystem, the incentives and the strategies that drive these arrangements. So enforcers, in a way, need to be ahead of the curve, and that, of course, is not a small task to ensure that there is no misuse of digital ecosystem and regulations don't fall short. Now, another distinction from the traditional market is that due to the data-driven and indirect network effects and multi-sided nature of these markets, the impact of the practices gets amplified and may not be confined to the product in question, but may actually permeate across several products and services, and thereby affecting the entire ecosystem. So any analysis which is undertaken cannot be in isolation and must factor in these interdependencies. And these, therefore, unique characteristics make it very difficult to apply the conventional competition law framework and necessitate change in approach and application. Well, there are very often efficiencies associated with these services which are offered. They bring several benefits to the consumers in terms of free offerings. At the same time, there may be consumer harm in terms of deterioration of quality standards, privacy, lack of choices, and adverse effect on competition. So in this backdrop, another challenge before the enforcer is how to weigh these efficiencies qua the harm, and how to strike a balance so that while we are able to address the harm, we do not take away the incentives for innovation. And in this regard, the approach of the Commission has always been thus to have a very proportionate and targeted, well-calibrated intervention, because the benefits that these markets bring to the table need to be retained. These are also epicenters of innovations and solutions for the problems which are being faced by the people. So striking this balance is at the core of the challenge. And assessment in rapidly changing digital markets also cannot be relied on a static approach, and what needs to be followed is a dynamic approach at every stage of assessment, be it defining the relevant market, assessment of market power, analyzing the conduct, or even giving remedies. Just to give an instance of how these approaches evolve, the dynamic approach the Commission has to follow. Initially, the online and offline markets were platforms were basically considered as just alternate distribution channels and were thought to be part of the same market. But over a period of time, when consumers started and businesses started relying more and more on these channels, what has emerged is a clear preference or distinct characteristic of the online markets, which may require them being treated as separate markets. Similarly, on the assessment of dominance, the traditional parameter of market share is losing its significance and and it is coming to the fore that it has huge limitations, and it needs to be complemented with several other considerations like the network effects, the vertical integrations, the countervailing forces, switching cost, and other such parameters which have to be duly factored in. And another important aspect which is before the Commission in attending to these cases is the need for timely attending to the harm that they may bring to the markets. Because of the very fast evolving nature of these markets, if we take too much time, the market may actually tip in favor of the incumbents, and it may be too late, or it may involve a huge cost to intervene. And that is why it is very important to review our processes, the entire legal framework, and deliberate that how this can be expedited. And lastly, one important aspect related to the issues which are coming before is that these competition issues do not happen in isolation, and very often the competition issues have basically interface with other policy objectives like intellectual property rights, privacy, and consumer protection. So this calls for a very holistic approach and a committee between regulators, and and also that we basically the entities do not use this as an opportunity for regulatory arbitrage. So with these points, I look forward to the panel to respond that how CCI can address these challenges. Thank you so much.
Thank you so much, ma'am. So a lot of issues have been raised by you, and we'll delve deeper into that. But let me also now invite Mr. K.D. Singh to deliberate on the processes and how some of these processes are now developing. What are the real-life practical issues being faced according to you as you see it as a regulator, and what is the regulatory approach towards these processes?
When we talk about emerging issues in antitrust enforcement, I see it from two angles. One is the substantive part, and another is the procedural aspect. Now, a lot of new issues and new proposals in terms of ex-ante regulations and to strengthen the existing regime, they have been recommended by the expert panel, Competition Law Review Committee as well, and the global debate is also going on. So substantively, even the existing law has been found to be quite robust by the expert panel. So it does not leave any type of anti-competitive conduct which is not presently captured. But to go for an efficient and smooth enforcement, we need to have both the wheels of substantive and procedural aspect going. Because if any one of them is not moving, then at the end of the day, the interventions cannot see the logical conclusion. So to my mind, apart from this discourse on substantive issues, we need to be very alive and cognizant of the procedural aspects, because they may derail the whole of the inquiry and the investigation process. In this, I would just like to mention that CCI has only recently completed 13 years of its enforcement experience. Now, 13 years is not a very long period in the journey of any regulator. If you compare it to any other law, for example, Indian Penal Code of 1860, now that has a rich jurisprudence of 160 years. So these procedural bottlenecks, they get accentuated in the context of a young agency, in the context of a young law that is more complex, being economic in nature. So therefore, these challenges are at the center stage. And until and unless we resolve these due process and procedural challenges, despite having a robust substantive regime, we would not be able to take the wheels of enforcement forward. So this is my first thought, that both substantively and procedurally, we have to be attuned and in step with the global developments. Having said that, coming to the specific issues I would mention. Now, for example, we have a new confidentiality regime in place. In antitrust inquiries and investigations, there are a lot of sensitive, commercially sensitive data which are given not only by the parties under investigation, but even by the third parties. Now, there is a challenge. Parties, when they provide such commercially sensitive data, they claim confidentiality and they assume that it will not be shared with the other parties to the proceedings. Now, here the challenge is when the party which is being proceeded against, as a part of due process and natural justice, they have a right to access the confidential data which has been tendered in evidence against them. At the same time, the third parties or the informant who have given their confidential data, they have a legitimate expectation that their commercial data will be protected. So how this balancing is to be done? Now, if we do not do this balancing, there are bound to be challenges judicially. And we have seen it in our last 13 years of enforcement experience that these challenges at the intermediate stages can derail the whole inquiry. Markets are very dynamic. We have to respond very quickly. In fact, the antitrust agencies have to aim the moving target. So our challenge is very big. Otherwise, if we complete our investigation after 10 years down the line, then we would not be making any market correction. That would be a post-mortem. So how we have solved this dilemma? We came out with a new confidentiality regime. So instead of dealing with the issues on case-to-case basis or in an ad hoc manner, we came out with an institutionalized mechanism of confidentiality ring. So under that ring, we provided certain safeguards within which controlled access is given to the parties who are being proceeded against so that their right to effective defense is not compromised, and at the same time, sanctity of commercially sensitive information which has been furnished by the other parties is also protected. So this is one example. But then there are, of course, cross-examination, personal hearing. A lot of issues are are in the process of being settling on what is the nature of inquiry. Inquisitorial, adversarial. The burden, the standard of proof, whether it is beyond reasonable doubt or whether it is preponderance of probabilities or it is something more than preponderance of probability like clear and. So that are the things which are being in the process of settling, but that is the, I think in the judicial ecosystem, it will evolve and develop over the period of time. So this is how I would say that procedure is very important and we need to supplement our substantive aspects on that lines.
Thank you so much, Dr. Singh, for talking about the processes and confidentiality you raised, and we will extrapolate on that particular aspect also a little later. But let me begin with some thoughts from the industry's side. Sanjeev Bikhchandani, a lot has changed, and the regulators in their speeches have constantly said that we have to target the moving, we have to aim at the moving target, or we have to stay ahead of the curve. The innovations will have to be encapsulated while striking the balance with the regulatory framework. So all these aspects put together, of course, it's a very fast changing space right now, and we all are evolving with it. How do you see in the last few years the regulatory framework really having an impact on the innovation as well as the business action of the companies and new age companies? And what are the key challenges that the sector faces at the moment while understanding these regulations and going ahead with their ambitions while at the same time taking into cognizance the non-dominance position and antitrust regulations?
Thank you. Thank you, first of all, to CCI for inviting me here. Look, I'm not an expert in the competition law. We run businesses, right? But common sense tells me that, listen, the technology is changing very fast. and you are seeing new business models emerge, new companies emerge, both globally and in India. You are seeing national barriers being broken down where, you've got global companies dominating India as well as local companies dominating in India, or being market leaders at least. Now, because, new business models have emerged, I think let us first focus on platforms and marketplaces. Because individual offerings or individual brands that go online, selling on their own website, generally cannot usually be accused of dominance and monopoly, unless there's some other factor. So if you look at marketplaces and platforms, very often these naturally end up being with one player being dominant, or maximum two, having significant power. And so these are naturally markets of network effect, virtuous circle. And we've seen that earlier in offline businesses as well. For example, if you look at the newspaper industry, typically in every city, you will have one dominant newspaper. And that's because those markets are naturally markets of the network effect, a virtuous circle. You end up with one dominant player. So it'll be in Chennai, it'll be one dominant newspaper. In Bombay, it's one dominant newspaper. In Calcutta, it's one dominant newspaper, and so on. And what does that do to reader's choice? What does it do to advertiser's choice? But typically, media being sensitive, nobody has looked at, potentially monopolistic behavior there. But that does not mean it does not exist. Right? Likewise, in online, in digital, you will find that there will be one dominant search engine, one dominant social network, one dominant, professional network. And these are natural monopolies. So I don't think CCI should try to fight nature. What the regulator should do is try and ensure that there is fair play, there is restraint, self-restraint. And here my advice to industry is better to be restrained and do it yourself than have it done to you by CCI. So it's okay to be slightly less aggressive. Okay? So I would say that if the market is naturally monopolistic, we should be looking at misuse of monopolistic position or power and not monopolistic position itself, because the market is naturally monopolistic. So the question is, how do you conduct yourself as opposed to do you have a dominant position? Right? Now, the regulator, of course, has a tough job, right? Because you want to protect the consumer. You want to ensure that the consumer has enough choice. But if the market is naturally monopolistic, what do you do? Right? At the same time, you want to ensure that innovation takes place. At the same time, you want to ensure that it's not unfair to the companies, right? Because they also have rights, although your primary focus should be and is to protect the consumer and make sure the consumer has enough choice, right? And look, this is natural. We are a country that was once colonized by a company, right? And therefore, there will be some, we have seen effects of that 250 years ago. So obviously you don't want, companies to have too much power, right? And I accept that. But look, the trade-offs, it's a bit of a tightrope walk. There will be trade-offs. The consumer, the company, innovation, fair markets, and so on. Legitimate, practices by companies need to be not acted upon or against, right? So I would say that because the environment is evolving so rapidly and has evolved so rapidly, I think CCI has its work cut out for it. And all the points that were made by Jyoti were extremely valid, that you have to really move fast and evolve, right? So as to understand what's going on and make sure that you're taking the right calls, right? I'll end here, but we'll get into discussion afterwards.
Right. Sanjeev, thanks so much. You raised a lot of important aspects which we can actually delve deeper into, the position work versus the behavioral aspects in terms of dominance as well. But let me first introduce Suraj Saran also into the discussion, another important industry voice. And Suraj, help us understand, there is a new development of omni-channel. a combination approach. Your company itself also cuts across the new age companies as well as the brick and mortar companies when it comes to logistics. Does this really require a new set of rules, and how does the definition of market really change in this environment?
Yeah, thank you everyone. So Nisha, to your question, yes, there is an overlap now as far as at least logistics is concerned for online and offline players. But when you think about an antitrust regulator, I think what Jyoti ma'am had said becomes very important. We need to start redefining the industry. We need to start redefining the sectors, and not just say it is retail because people are buying stuff directly from the companies, but defining online and offline in that context. Because when you're looking at platforms, you actually want to see whether one of those platforms or one of those players has a dominant position which they are likely to misuse or are misusing, right? And that's the behavior you want to eliminate by implementing these antitrust laws. So market definition is one of the important starting points on how do we think about these laws for implementation in the future. A couple of other things that I just want to talk about, having heard what people had said. I think procedurally, Mr. K.D. Singh had said, procedure becomes very important. And, you don't want processes and procedures where if somebody puts a complaint against you, you're actually not able to conduct business, right? You want this not to become what our judiciary is like, right? You don't want a consumer putting a case against a company and that goes on for 10 years. That doesn't help anyone, right? When we think about antitrust laws, we have to come up with timelines which do not hamper business, right? That's very important. The other thing that I think is important is that there's very little awareness about anti-competition. I'll be honest, we are a 11-year-old company. We know CCI because whenever we raise any funding or if we are trying to acquire another company, we have to come to CCI to get an approval for combination. Right? That is not the topic of discussion of this panel right now, but other than that, we've never in our senior management discussions ever spoken about making sure we are compliant with the competition law, right? That never features in any of the boardroom discussions. And I think that is something that has to become important, and awareness has to be built around it. Because unless companies proactively start thinking of not doing something which hurts or sort of gets them hauled up by the CCI, the proactiveness of what we are trying to achieve here through this discussion is never going to come by. And I think that awareness hence becomes very, very important. Also for the consumer, right? Ultimately, while companies, we do know CCI because of like what I just described, but as a consumer, I feel that less than 2% of people probably know what CCI does and where it can help them, right? So if they're feeling the pressure of a player because of the way they're operating, I think they can come to the CCI. That's something that is unknown. And I think awareness on that front has to be built as well. I think I would agree with Sanjeev when he says that, don't try to not have dominant players. I think dominance does help consumers in certain industries, right? As an example, in logistics, the larger we become, the cheaper it will be for people to use logistics service, whether it's an individual consumer or companies, and that ultimately helps the economy, helps the consumer in some way. So dominance, we should not try and prevent dominance. In fact, we should try and eliminate barriers to entry, right? There's a classic example of Nestle Cerelac, right? In the infant baby food space, it has over 90% share in India. But that's not because they're the best, but it's because there's a ban on advertisement for this category in the country. And so no other player can actually enter and compete. And so that's what you want to eliminate. You don't want to eliminate dominance per se. You want to eliminate bad behaviors that come as a result of dominance. And you want to eliminate barriers for newer entrants to come into the market.
Right.
And I think those are the key sort of points that I have.
Nisha, before
Yes,
you
sure.
proceed, if I may take
Yes,
this
yes.
opportunity to respond to this point which has been raised, very pertinent point about dominance per se not being bad, but it is abuse which is frowned upon, and this is exactly what the philosophy of the modern competition law is, where we do recognize that being big brings along economies of scale and efficiency, and it is the abuse which is basically checked.
Right. So well pointed out. It's a very interesting point, because the digital revolution at a cheap cost wouldn't have happened in India if there was no dominant position. So sometimes it's in favor of the consumers, and the entire startup ecosystem got developed only because of that being such a big smartphone market. But I want to understand the market approach and the focus a little better because of the developing trends that we are seeing, and Dr. Rajat Katuria can reflect on that. Sir, help us understand the new definition of market, and what are the challenges faced in defining it, and therefore is a new approach required?
Thanks, Nisha. But before I answer that difficult question, let me thank the chairperson, Sangeeta, Jyoti, everybody who's sorted fit to invite me to this really interesting panel discussion. So thank you very much. Let me start by saying, so the markets, the relevant market definition definitely needs some discussion, but markets by itself, they don't need a redefinition. Although, one would say, so I'm going at a very high level. Do you need a new, do you need a new law, competition law? And the answer that I'm hearing, Sangeeta and Jyoti and Dr. Singh have said all that I wanted to say, so I'm going to sort of package my thoughts differently, but essentially, I'll come to the conclusion that they've come to. You probably don't need a new competition law. You need to tweak a little bit because it's probably all-encompassing. It's sort of fairly flexible, and it'll be important how you enforce it. And here, before I talk about markets, let me say that, a lot of sort of competition literature, not only in India but across the world, is focused on creating, as Suraj was just saying, barriers to entry or buying time for the sort of complainant. And I think that's something the CCI and judiciary in general in India should recognize, because this is a sort of instrument that is used by an affected party to delay and continue in the market. And I think if CCI makes an example of this, these frivolous cases that come up, if CCI can make an example and set that, we will not entertain such ridiculous cases because we know the strategy is to create entry barriers or to, give you more time to assess or to milk the market and so on. So I think that is something that both the Indian judiciary has been grappling with since independence, I think. In this sort of market, definitely there will be lots of frivolous, there are lots of frivolous complaints that are made, and I think CCI must see through that. Let me sort of go at a little higher level and say that, when outsourcing became really dominant across the world, and where America was facing the sort of music in terms of a lot of business going to China, India, services coming to India, manufacturing going to China. No less an economist than Paul Samuelson wrote an article, do we need a new sort of theory of international trade? And Paul Samuelson is a sort of Nobel Prize winning economist. Do we need to look at a new theory of international trade? Because fragmentation of the manufacturing line had never happened to the extent that it was happening due to outsourcing, and that was due to transportation and logistics. Components could be made and shipped to different parts of the world. And comparative advantage had never been looked at from the point of view of the value chain or point of view of components or the point of view of the tasks. Comparative advantage was always in terms of labor-intensive, capital-intensive. India has a comparative advantage in labor-intensive goods, and America has a capital advantage in technical-intensive or capital-intensive goods, etc. That was the sort of accepted paradigm of international trade, and you traded, and India would benefit from labor-intensive or labor-intensive manufacturing, and so on and so forth. And so this whole thing about reevaluating international trade due to components and tasks and fragmentation of the value chain happened. And our own, and I'm saying this because I want to respond to a very, very important point that Sanjeev has made on colonization, and I'll come back. That will be the last point I would make. But I'm using this as an example to buttress what I'm going to say at the end, what Sanjeev said, which is that you didn't need Panagaria, Srinivasan, Bhagwati, are three sort of trade economists. Panagaria was here, you know, as vice chair of the Niti Aayog. He teaches at Columbia. Bhagwati is a very well-known trade economist, and T.N. Srinivasan also. He's no longer with us. But three of them responded to Samuelson saying that, look, you don't need a new theory of international trade because, you know, whether it is labor-intensive manufacturing or whether it's tasks and components, your competitive edge or comparative advantage is still defined by what you do well. What is your comparative advantage? Whether it's in tasks, whether it is in assembly, whether it is in production, shipping, logistics, whatever, but it's still comparative advantage producing at lower cost. As Suraj was saying, that if you're big, you'll produce at lower cost, enjoy economies of scale, and then you would become competitive in that. So, and I think if you translate that entire Nisha paradigm, you don't really need to you need a new definition of markets. I mean, you need new definition of relevant market, but markets, you know, will work well. The new thing that we need to do, and this is sort of important for us, and this is the main point that I want to make. If you look at America, very laissez-faire, market will correct itself. If there is no consumer harm, the Bork hypothesis would say, you know, you'll mess up much more than you would, you know, improve. So don't intervene. The Friedman Chicago School approach to, you know, laying off, markets will correct themselves. They have this inherent tendency to correct themselves. And also the argument of size not being abusive was that you would achieve economies of scale. So that was the American approach to antitrust and competition. And I think that lasted for a long time. That also served the interests of American companies that wanted to do business abroad. And they continue. I mean, there is big movement in America from the big, you know, the big tech companies to say that allow us access to data, because if you don't allow us access to data, we would lose the innovation and artificial intelligence battle to China, which gets access to it. It's a self-serving argument, but it is an argument. Fortunately, I think the FTC and the Department of Justice in the United States have changed their approach. They have become much more interventionist than they were. The laissez-faire sort of approach to regulating markets now doesn't, you know, Raghuram Rajan from Chicago has written an article on the kill zone, saying that a lot of these companies just acquire and kill innovation. And the kill zone shouldn't exist, and he's absolutely right. But you should also create a balance between, so what destroys innovation and what preserves competition. So that's also a balance that needs to be created. But yes, here's the point. The theories of markets, I mean, the approach to regulation is changing in America. Lina Khan, I don't know if you've heard, anybody's heard of Lina Khan, is now with the FTC, and she wrote a very influential article in the Yale Law Journal called The Amazon Paradox, which was sort of using the same title as Bork's Antitrust Paradox. And if that is the way that markets are being approached, then definitely there is much more intervention in a country that was historically laissez-faire. Sometimes self-serving, sometimes, I think, genuinely laissez-faire. And self-serving, I mean, because it protected its big companies to do business abroad. Our paradigms, and this I'm going to, so I think we don't need a new theory, we need a new sort of approach to intervention and enforcement, and I will end with that, but I do want to make a point on Sanjeev's important point of colonization by big companies, and I'm going to use colonization in a much larger approach. I think we need to sort of get away from using the paradigms that are developed in the West and adapting those as gold standard. I'm not saying you chuck everything away, throw the baby out with the bathwater, but every country, every individual space operates differently, whether it's cultural, And CCI has to look at cultural aspects, has to look at sociological aspects. You can't say that America practices laissez-faire, so I'm going to do it. Their culture, their approach is very, very different. So this colonization simply is not an idea that we are being colonized by big tech. We are also being colonized, and we have been, by standards. And I think, not only CCI, but we should develop our own standards where we think we will be able to apply and for our own benefit. We have been shy of doing that, and I think we should approach it, the literature, which is a very old literature, and this is my new foray into academics, which is I'm really enjoying. I was telling Sangeeta that there is a whole subject of decolonization and enforcement and the digital, which we need to look at for our own interest. And I think Sanjeev pointed this out, and we should really approach it through that perspective as well. I'm not saying discard everything because it is emerged in America or the United or Europe, but look at what works for us. The last point I wanted to make, at the cost of being sort of long drawn out, is enforcement. Given all that Sangeeta and Mr. K.D. Singh have said, I think there are three ways to do enforcement, two which are recognized. One is, of course, your conduct remedy, thou shalt not, cease and desist, you shall not do it, etc. Sometimes we do it, sometimes we don't. The other is, of course, structural, which you break up the winner-take-all market. But you broke up AT&T, AT&T has become big again. Digital markets will be winner-take-all. So structural remedies, I'm not sure how it will work, but I don't have enough insights into this. Price remedies also, given multi-sided markets, multi-homing, etc. I don't know how much price or cease and desist will work. Not only price, but as Sangeeta said, you have to look at a whole gamut of non-price issues as well. So conduct and structural are, the standard enforcement techniques by all antitrust regulators. And there's been cat and mouse game. I will fine you $45 million. You pay, you sometimes don't pay. I'll ask you to reveal your source code. You do it, sometimes you don't do it. All this cat and mouse game between regulators and with industry or companies will continue to happen. But I think I was very struck by what the chairperson was saying in a huddle there before we came onto stage, and I told him this is exactly what I wanted to also say, is that, can you make the companies partners in the enforcement, something that Sanjeev talked about, self-regulation, or even going beyond self-regulation, is that, structural and conduct remedies will work, may not work. Behavioral change or nudging them to do the right thing, doing good by doing the right thing, is also an approach that is worth considering, especially in digital markets, where it becomes really difficult to enforce and monitor, right? Let me give you an example. This is something that I was associated with in TRAI. I spent a lot of time working in TRAI, and a lot of my sort of experience is working inside TRAI in the economics division. Now, when Geo came into the market at almost zero prices with data, a lot of people said that's predatory in nature. But as Sangeeta just pointed out, well, they had no market share in telecom. So what do you do? Zero market share, no dominance, and therefore dominance is an instrument. Abuse is a feature of dominant players. Is it? That's a question. Do you look at, what their other business? Clearly, Jio is financially dominant, but this was a separate market. They had no presence. Retrospectively, we know that they disrupted the data market in a way that it hasn't yet recovered. Even today, the telecom market is still not recovered. But should you have intervened then? What was it that you would have used as a rule or a law to intervene at that time?
May I comment on this, Rajat?
Yeah. Sorry, please. Yeah, go on.
Sorry.
And that's
the question is, has it benefited the consumer?
Sorry?
The question is, has it benefited the consumer, this data revolution? And if that had not happened, would we be where we are today? Is this good? So, I mean...
That's right.
So it's an open question.
It is an open question. I'm saying it is an open question. Should you have intervened then or not? It is clearly an open question. But those are sort of defining questions for the market. They will sort of pave the way for how the market evolves in the future. So what I'm saying is that other than price, predatory, cease and desist, of course, mergers and conduct and structural remedies, I think it may not be a bad idea for regulators like CCI, who doesn't make the rules but enforces the rules, to try and see whether partnership and collaborations can be a way out from this difficult, market regulation. Thank you.
Dr. Rajat, you raised a lot of points and a few controversial ones as well, which is very interesting, and everybody has a point of view on that. But one thing that came out very clearly is that the definition of market is going to be playing a very critical role, which Sanjeev had also alluded to, and needs a lot of deep thinking here as combinations are also coming in place. But one aspect that you clearly highlighted is very interesting, is that the tactic of delay and time-bound resolution, which CCI from inception has been saying that we must adhere to, and that is something which is the crux of the entire, ecosystem, because the companies want to take action in a time-bound manner because the market changes very quickly, and that same action may not be as relevant later. So that is still something that I can easily say that the entire industry looks up to CCI for even today. Though I know, and I'm tracking many of the mergers and acquisitions which are right now under deliberation for quite a few months. But let me welcome then another speaker, Ramji Srinivasan. A lot has been spoken, sir, on the various aspects, but one aspect that I want to clearly understand is the global developments in the new age space. And that is one area which Indian markets and globally, because of most of the competition laws being in sync, because the new age space doesn't have boundaries, we all need to align to that. So what are the global developments which can have a bearing on India, which are interesting developments? Killer acquisition was mentioned, and even a lot of vertical and horizontal acquisitions and combinations are being talked about. But what are the new aspects developing, and what should the Indian online companies should look up to as emerging trends in this space?
Right. Thank you. Thank you very much, Nisha. Thank you very much, Honorable Chairman, sir, and Honorable Ma'am, and members on the dais for inviting me to this August gathering, another opportunity for us to exchange thoughts on an extremely important topic, emerging issues in enforcement or antitrust enforcement. So obviously we've seen something which has been in existence for a long time, 13 years as Mr. K.D. Singh mentioned for India, and I have seen from the very first year of the existence of CCI how this has progressed by leaps and bounds. So I will only to one extent differ with Dr. K.D. Singh, which is that despite its young age, it has leapfrogged, and Indian CCI is in the reckoning of one of the top agencies, enforcement and competition agencies in the world. It holds a pride of place in the ICN and at the high table, and it's because of the impact that its actions have taken. And some of that interesting data I've got, but I will share that with you in just a minute. But before I come to that, two other things. One, which is that 100 years ago, actually 104 years ago, we had the last big, huge pandemic, the Spanish flu in 1918. And that resulted in not as much disruption in our world as this pandemic in the last 2 years has. So today, if we are talking about an emerging issue as we sit together to debate what are the emerging issues, one of the biggest factors, in fact, the most important factor has been this pandemic, which has shaken. And when we say that some video has gone viral, we know how viral really means. So therefore, this virus has engulfed all of us. But that has resulted in some tremendous development for consumers worldwide. Who would have ever imagined that we'd be sitting in the last 2 years conversing with people, almost space age-like. It takes me back to Star Trek. Short of saying, beam me up, Scotty, I'm on my iPhone and I can actually see somebody across the Atlantic and speak to him or her and have conversations and have exchange of international seminars, which we did successfully earlier also, and have court hearings and have judicial disposals, have people access to courts. Incredible. And all of that happened because I think personally that the CCI did not intervene when Geo came to launch its data. And I'm just joining issues there with my good friend because it's a different matter. I happen to appear for Geo.
Purely coincidental. Purely coincidental.
So, quite apart from that, also the fact that the incumbents wanted to injunct Geo. And they moved court and said, no, we don't want you to do this kind of a zero tariff that you're coming up with. It's predatory. You just stop. You shouldn't allow. We will all die. Costs will go up. Thank God there was no intervention. There was no injunction. So today, if we have the results, and to say that no, they haven't recovered, I again wish to join issues with my friend. Today, Airtel has reported profits. Airtel. So therefore, it would have been very difficult for anybody, and even less, we are not, even though we would want CCI to be Nostradamus, it is impossible for you to predict the future. And therefore, it is better to err and allow innovation. And that's exactly what the CCI has done throughout. It has fostered innovation. It has not, to borrow a phrase, gun jumped. It has allowed innovation to happen, people to fight it out in the marketplace, and then see what the effects of those are. And that's extremely important, and we have this today. If today people can, and poor people can, over the mobiles. I don't remember. I mean, I think, when we first had mobile phones, it was 16 rupees 80 paisa per minute. And to receive was also the same.
Yeah.
Today, and before the Geo's launch, data prices were for some 4 MB or 5 MB or 2 GB, you had to pay 500 rupees or 5,000 rupees or 2,000 rupees. Some enormous costs. But look at the way everybody else has played out. This has been one of the biggest factors in allowing innovation to happen. And this is how we are able to converse. India's prices have come down the lowest. And in telecom rates, we have been proud of how the prices have come down to paise, no longer rupees. And that has percolated now across sectors. And we're able to access people, and that has a direct bearing on the GDP in terms of economy. The economy has run, and that is extremely important, not individual fortunes. So therefore, if we take a leaf from that, all that I would say is this. Just imagine this extremely important piece of statistics. In 2021, a year after the pandemic, which brought the whole world to its knees, do you know the value of transactions that occurred across the globe in terms of mergers and acquisitions, takeovers and investments? Just mergers and acquisitions were $5.8 trillion worth. 1 year after the pandemic. This is the changed hands as a result of corporate mergers. This is a 64% increase over 2020. The pandemic never stopped anybody. There was a brief hiatus. It has thereafter accelerated business opportunities, accelerated growth in economies, and economies which have been forward-looking. No brakes were applied. But it has brought together with it prosperity, economically, access, information, consumer benefits, opportunities for people here, the industry, for them to grow and prosper and to come up with something completely different from global, originally intended brick and mortar industries. I always maintain this, and on that I completely agree with Rajat. We don't need new laws. Our existing laws are good enough, they are wide enough, and they empower the CCI. Many people say CCI no teeth. I beg to disagree there. If it wants, it can be one of the strongest regulators, and it has done that. It bites where it's required, but it has, as the Honorable Chairperson was also mentioning today, the concept and the philosophy has been one of trust in the industry. Allow them to grow. You are equal participants. Share with us full disclosure of what you are doing, and then leave it to us. We are not intent on stopping anybody else, but we want to make sure the motto of CCI is fair play, that you're playing fairly. Nobody's going to change the rules middle of the game. That has led to massive number of the highest number of unicorns in this country, which we should be proud of. Which means it's a market valuation. But what it means is innovation is thriving. And people and financial sectors are willing to bet their bottom dollar in these thriving innovations. That is what is required. That is the spur that is required by a competition agency, not to stop, but to allow. That decision, of course, is always very difficult. When to stop, when to intervene, that will be very difficult. But so far, we have erred, and when I say we, I think that I belong to, institutionally the CCI as a student of competition law. In India, we have erred on the right side. And we have allowed all of this to happen. The fruits of all of that will happen. But at the same time, cautioning and balancing both innovation, the CCI has not stopped short, and it has come down where it thought that there was abuse or possible abuse. And therefore, while approving mergers under the Green Channel and speedy expedition, it has also warned. Market studies have been done with the participation of industry to make sure that you learn exactly how businesses function. There are different variations, omni-channels, multi-channels, to understand the market, and therefore market studies have been commissioned with the help of industry participants and experts, and that has yielded great results, and some of which are also part of a recommendation made by the CLRC in 2019, and hopefully in this monsoon session, I think some changes will be on the anvil, including possibilities of settlement. So that's a pro-business activity and a pro-business attitude that the CCI has shown. And therefore, this digital decade, it was already there in the offing, but the manner in which people used to come to me for conferences, advocates and clients, lugging in files all the time, big, huge files, and sitting and meeting. And I used to say, I'm already ready. I've got a large screen, I'm digitally equipped, I operate out of an iPad. Why don't you do the same thing? But the environment and the ecosystem wasn't ready. But this pandemic, as the Honorable Ma'am also mentioned in the opening, has accelerated everything else, digital usage. So that has really happened. Yet together with that, at the same time, speedily, in the last 1 year, the CCI has come up with remarkable number of decisions in enforcement. And I'm only mentioning this because the topic is emerging issues in enforcement. In 2020, between June 2021 and 22, 14 major decisions in enforcement actions have been taken by the CCI. Apart from mergers, and I'm not touching, that's a subject matter for this afternoon. But what is most important is to recognize the platform economy. That platform economy, therefore, has thrown up new challenges. And those new challenges is what Jyotiji mentioned in her opening address. Multi-sided economy, two parties, multiple parties, demand, supply, an amalgamation of the traditional brick and mortar concerns and new age concerns. To meet this, therefore, and to answer Nisha's question, today in this emerging world, what are the developments globally that are happening? DOJ in the US has partnered together with FTC under the leadership of Lina Khan to say that we are now going to make sure that we have adequate measures to understand and regulate, if required, big tech. Europe has done exactly the same, and they have gone ahead, Margaret Vestager has gone ahead and partnered with the US to exchange information, and there's a joint council that has now been set up to understand what impact digital tech and big tech have. And therefore, and not only this, UK has gone ahead and set up its own DMU and DMA. So the DMU is, like Jyotiji mentioned, in India, and our CCI is also contemplating a digital markets unit. Therefore, to examine this very carefully, because this is going to be the biggest challenge in the next decade. And therefore, abuse or processes. So economic activity, understanding, all of that will happen. Dr. Payal Malik will obviously be going to be contributing to all of this to understand from an economics division how this can. So food delivery, online booking, search engines, online retail, online cabs, operating systems, online payment systems, all of these have now got the attention of the CCI. They are all facets of platform economy, a digital economy. And we are not far back. So therefore, apart from this, the UK has also gone ahead and enacted the DMA, which is going to be operational. They're saying hopefully by end of this year or maybe next year, early next year. And that has got certain objectives, but most importantly, to make sure that there is no abuse. Ultimately, as consumers today, if we were to go to the markets earlier, brick and mortar, to shops, the shops have come to us. The markets have come to us. But are we going to be subjected to only one platform and locked into those? Or should we have more alternatives and a freedom of choice? I think that will be, and I'll address that in a little more. I think I may have taken a little longer, but I hope that this is what is something that is going to occupy all of us.
I think you emphatically made a lot of points about your case as well, and we erred on the right side, and hope we err on the right side more often then in the interest of innovation and the consumer benefit. So that point very well made. But finally, I want to also introduce our, final participant on the panel who's been waiting very patiently. Thank you so much, Manu Chaturvedi, but now you are much more enriched in terms of everybody's thoughts, and you can reflect a lot more on the specific aspects that have not been brought about, especially the deep discounting issues, the practical issues that you as a legal expert face on a day-to-day basis. And also I want to ask you about this new age space is not one sector. We were enumerating the number of sectors in which the digital platform is used for these businesses. So the regulatory alignment and the CCI aligning with the regulators in each of the sectors, is that also a massive aspect that we are working towards?
So thank you for that wonderful question, and thank you for having me on this panel. And yes, as one goes last, one of the issues is that there's so much that's been said and so much that can be responded to, both as a student of competition law and as a practitioner, that I'm actually trying to assemble thoughts in my head as to where to go first. So I'll actually just take lead from your question, and I'll sort of just circle back once before I get into that to what Dr. Singh was saying, what Mr. Singh was saying at the beginning, because as a practitioner, it's of great interest to me. It was mentioned that, we're balancing essentially two interests. We're balancing the need for a quick investigation, timely intervention, versus obviously the expectation of the industry that if it is indeed a stakeholder in this enforcement proceeding, in this investigative process, then its interests in securing confidentiality over the information that is shared either voluntarily or that is obtained from it through other means is met. And one of the experiences that I've had over the last few years with certain cases is that the older confidentiality regime, just like many other procedural aspects, was used almost as a tripping stone to go to court and to sort of scuttle investigation or prolong it further. And that sort of defeats the entire purpose of timely market intervention. And, as Dr. Singh was saying, it probably just leads to a post-mortem of sorts and not a real-time market intervention. And the confidentiality regime, at least in some of the cases in which I was representing CCI, this was extremely central. And the new regime actually resolves it to an extent, and I'll just get to that. But there is a lot to be done at the NCLT and the appellate level and at the writ level with respect to the same issue, because that cannot be done by the Commission. So what do I mean by that? What has the Commission done? So there were principally two grievances that we had from the industry side when it comes to the procedural framework of confidentiality regime. Two principal grievances. One was that in effect, and the confidentiality regime was merely a part of it, but a big part of it was that there was automatic confidentiality afforded to the informant, and that sort of formed the basis of a lot of pleadings. They wanted, so any opposite party which is being complained against would, when the investigation was being, proceeded, would take this to a writ court and simply say that we don't know the identity of the informant, we suspect it's XYZ, and we want disclosure, and until then we want to stay on whatever is going on. And courts are once there's an order, the courts are inclined, just in the interest of justice in such cases, that, okay, you stay your hands, let's at least preliminarily investigate this issue. So one was that issue. And because these were sort of stumbling blocks that were put there effectively to stall investigation, or, maybe that was the consequence, it might not have been the motive. So that was one aspect. The other aspect was obviously sharing information. So, and this is a completely reasonable demand, that if I am sharing any documents which are extremely commercially sensitive, which involve trade secrets, which I have actually withheld as an industry participant from my own employees, and if I share it with the CCI, and you grant confidentiality after the fact, then I will be a little more tentative in sharing that information. And if I take that amount of time, and if I again present information in a piecemeal manner, then the investigation obviously prolongs, and the prima facie preliminary stages of the investigation obviously need to unfold in a much more slower manner. So what the new regime does is addresses both of these aspects, right? And that's a very strong and clear signal that the Commission is sending, that we are balancing industry's interests and also our need to regulate, especially the new spaces. And how does it do that? It creates a self-certification mechanism. So today, if you're the industry and the Commission reaches out to you and it says we want XYZ data, you don't have to submit that data. You don't have to go back and forth with the Commission trying to ascertain whether confidentiality will be granted over that data or not. You can simply self-certify that this data is confidential, I'm sharing it, and that's the end of it. The Commission, in fact, in its, and correct me if I'm wrong, in the draft proposal for this Regulation 35, there was actually a provision which allowed the Commission to review that after the fact. But that too was dropped after consultation. And a separate clause was put in for false undertakings, but that was removed. So that is the extent to which the Commission is cognizant in a dynamic way of what the grievances, potential grievances, roadblocks of the industry might be, so that those can be removed and there can actually be stakeholdership which is meaningful, and we can all contribute meaningfully. The other aspect which I referred to was the informants, automatic anonymity being afforded to informants. And I think someone mentioned here that that's one of the problems, that the Commission should be in some way discerning of the Commission's time being used by opportunists who are basically just in an in personam dispute, and not really an issue that concerns competition law. And to that, again, I think the amended regulations are fantastic. They simply state that there will not be any confidentiality automatically afforded to the informant. There's a higher standard now that has to be met by the informant. And I think this amendment actually happened in 2019. On the heels of that amendment, recently, Regulation 35 has also introduced what Sir was talking about, which is the confidentiality rings. Now, this is where I'll segue into where that Regulation 35 and the new confidentiality regime might not take us the distance from a practitioner's point of view. So how do these things play out? So usually information is filed, investigation is done. During the course of the investigation, a prima facie order is passed and then investigation is done. But during the course of investigation, various parties claim confidentiality over various documents that have either been voluntarily submitted to the CCI or have been obtained. And various other parties claim as a right of defense that we need access to these documents to effectively mount a defense, especially during the final stages of the CCI's deliberations, when the investigation is over and when the final order and the final hearings are taking place. So how do you balance this? Earlier, the system in place was basically sort of ad hoc when it came to something like this. It was on a case-to-case basis. Now we have a system of confidentiality rings at the Commission's level. So what does that mean? That basically means that that the Commission gets to choose on a case-to-case basis that yes, balancing the right to defense versus, versus the whole investigative process. We need to sort of balance these interests, and it will create rings that are comprised of both internal and external members of the respective parties. And they'll have access to these documents, and those documents will in turn form the basis of whatever is the rebuttal that needs to be placed. But this only happens at the Commission's level. At this stage, even once a final order is passed, external counsel for the CCI are not really involved in the matters. We only come at the writ stage or the appellate stage. Similarly, it might be the case that certain parties are not part of confidentiality rings when they're initially determined by the commission while the proceedings are going on before the commission. So when you come in appeal or when you come in writ, there is a complete lacuna. There is no system in place either in the High Court except on the commercial side, and there's no system in place at the NCLAT, at the appellate stage, which sort of mirrors this confidentiality ring regime. So I think that problem will still remain. So while the process in front of the commission might go smoothly, and I don't think the commission can in any way, it can't make regulations for the NCLAT, for the Delhi High Court, but there definitely needs to be some deliberation on that aspect, because once you come to the appellate stage, what do you do if the appellant is relying on confidential data? And what do you do if there are people in that room who are either part of the appeal as respondents, or who are filing their own cross appeals, or just anyone else in the court?
So Manu, you emphatically made that point that there is some lacuna that
Absolutely.
CCI needs to address, and I'm sure they are listening to your suggestions as well. Very quickly on the regulatory alignment aspect,
Right.
Any thoughts?
So yes, many thoughts, but because the matter is again sub judice in a way, and sort of involved in the case, so I'll just keep it to this. It just seems that there was a case in 2019, if I'm not wrong, the Bharti Airtel case, and that's sort of being used as a universal aphorism or a universal principle of sorts, that the CCI's jurisdiction is in some way, comes after the jurisdiction is exercised by the sectoral regulator. Every time there is a sectoral regulator. And usually, when it comes to big tech, when it comes to bigger companies, there is usually a sectoral regulator already in place. I'll just leave it at, that is not what the judgment says. And we are seeing the Delhi High Court already clarifying that in a couple of cases in Monsanto, etc. And what we'll see down the line, hopefully, is a recognition, a judicial recognition of the fact that at the end of the day, the Competition Act itself takes care of many of these dialogues that need to happen inter, say, sectoral regulators and the commission. Yes. And there are provisions in the act which allow for that dialogue explicitly, both ways.
Very important point made there. And total alignment when it comes to judiciary, CCI's policies, as well as the sectoral changes that each of the sector regulators really put in place. So that ecosystem is yet to be developed, and there is a lot of understanding that is now evolving. To that point, and telecom seems to be the subject of choice for everybody, looks like, on the panel, but data, a very important tool, a very important weapon now, and on which the new age companies, the telecom companies, everybody is operating. And we also have data privacy aspects to look at. Now, I want to understand probably first from the industry. Suraj, you want to take this question? How is the regulation over data being understood by the industry? Is there enough clarity? And where does and how much does CCI wield power over this aspect?
So, in fact, I think just last week there were some changes to what data MeitY wants companies to sort of publish and who fall under that ambit of the law that they're proposing. So there is very little clarity, honestly. I mean, we keep debating whether we are party to this or not, because the way it's structured right now, we, being a service provider, do have data on customers, which has been given to us by the sellers who we are servicing. But do we need certain compliances to make sure we are in sync with the law? That's a little unclear at this point. And I think CCI, when you think about, when we think about implementing these antitrust or enabling competition and creating laws, I think one of the functions will be to coordinate with all the other government departments that are involved in especially the data side of things, right? It has to be coherent with what enables competition, what enables the best outcome for consumers ultimately.
Right. So, Jyoti ma'am, would you like to add to that? Because data privacy laws are being framed by the government. That is not under the ambit of CCI, but data is a very powerful tool based on which dominance can be proved. So how are we really handling that situation? Probably Jyoti ma'am can take it and Rajat can add.
Yeah, very rightly said. Data, in fact, is assuming center stage in our competition law matters, and particularly those related to new age markets. And definitely there is a very close interface with competition law. As far as CCI is concerned, we are interested only with the competition aspect of data. There can be both exclusionary and exploitative effect of access to data. And as I mentioned in my opening remarks, increasingly we are finding that the competition issues will not happen in vacuum or in silos. There will be interface with other laws of the country, and also CCI being a regulator which has its role cut across sectors, there will be also interface with the sectoral regulators. So going forward, and we all have to exist together in a congenial manner, and the law also provides for a very robust interregulatory interface, and going forward we are going to increasingly rely on that. In fact, CLRC has also recognized this, and their recommendations of making this exchange even more robust will go a long way, and we see ourselves working in close coordination with other authorities dealing with data in the
All right, collaborative approach and close coordination, and a lot of conversations with various stakeholders. Rajati, I have quickly a point to make.
So, data is going to become a competition issue. Sangeeta in her opening remarks said price and non-price factors. So I think data is already, and there are so many aspects to data that, you could take the whole day. But one example of this is, Apple is now advertising that your data is safe with us. We're not going to, your data is secure. It's clearly a sort of a competition issue, right? Now, if that is true, then it's going, and if they're going to make that claim, and if there is competitive sort of pressure on others to also adopt those same security and privacy standards that Apple is seeming to adopt, then I think it will become even more challenging for the regulators to be able to get access to data for whatever security. We've already had one case in the United States about of Apple refusing to give the data, the key for access to data of the phone of the gentleman who was involved. So I think this is going to become, it has already become a competition issue.
Yes, but I think the distinction between privacy and private and non-private data,
of course,
and as that evolves, which will clarify a lot of issues.
It will. There's non-personal data, there is personal data. But, one more point on sectoral, the interface between sectoral regulators and the Competition Commission. You can't, oust the jurisdiction of the Competition Commission ever. Even if the presence of a sectoral regulator, because how do you define an issue? And since the telecom is the flavor of the day, is an interconnect issue not a competition issue? But interconnection is, the rules are made by the regulator and enforced by probably the regulator and also by the CCI, because it is a competition issue. The only way out of this in the data economy, where you're going to, I don't know whether you're going to have data protection authority or whether you're going to have sectoral regulators looking at data for different medical data, financial data, RBI is already. So what that relationship between the sectoral regulators, including RBI and CCI, is going to be, I think the best approach, I think, at the sort of macro level is going to be a collaborative approach. There's going to be no ex ante way of delineating the legal issues across these two regulators.
Can I just on the data point? Very, very important. So, what are we talking about when we say data? Data is a concern, and privacy, and so on and so forth. On the one hand, we have the requirement of keeping my data private. It should not be available to all and sundry. My private health data, my fingerprinting data, and all of those should not be, because it has to be secure. It can be abused. Anybody can impersonate, use my data, abuse, and then I know that's one aspect of the matter. That's privacy issue. What we are concerned with is the power of data, which can influence market. So if you have, so therefore,
that is the main issue.
So what is the economic power that a company in this today's data-centric market holds, which acts as, and to use that word, which is now very popular in the platform economy, acts as a gatekeeper. It doesn't allow others to access that data, but it has all the data about you and me, and then he can go ahead and do two things. One, self-preferencing, which means that he goes ahead and promotes himself. He knows what your preferences are. He uses that the others don't know. And secondly, to go ahead and market, oust that, and not make that available to others to access.
So there is a very, very popular movie on this explaining exactly this, and Senate has questioned all the big companies in the US regarding this, which was very, very interesting, and everybody should watch it. So we haven't yet come to a conclusion on the data and the abuse of data and the power that it holds. But I want to throw in one more aspect, that is the vertical integration, horizontal integration. I have observed that vertical integration is seen in a very different light in the new age companies, while for a brick and mortar and traditional companies it was considered very good because a company is going into back-end integration as well as upstreaming, and therefore the entire bouquet is giving them the benefit of that margin. But that is not how the new age companies are being looked at. So should we ask Sanjeev to first reflect on this, and then probably CCI can answer?
See, I think vertical integration is a perfectly legitimate business strategy. Companies do it. And but if a platform or marketplace also has an offering, right, what needs to be ensured is that the platform stays neutral, it's a level playing field, and the platform's own offering is not given priority or preference by the platform over other offerings. To make sure the marketplace stays neutral, especially if the marketplace is dominant or has a very high market share, right? So I think you've got to distinguish between vertical integration and neutrality of platforms or marketplaces. If you can ensure neutrality, vertical integration is fine according to me. And it may even benefit the consumer. So let me put it this way. If there is one example, so let's say there's a food tech aggregator or a food delivery service as a platform, right? And on that platform, you can order food from many restaurants, up to you. Now, if that platform decides to launch a cloud kitchen of its own, right? When there are other competing cloud kitchens, then you've got to ensure that there is transparency, there is no special preference given here, and the customer has real choice. And so it's still a level playing field. The platform is to level playing field.
Right. Jyoti ma'am, you want to...
If I may quickly respond to what has been said, exactly, I think I would second what has been said here, and definitely our law recognizes that these vertical arrangements can bring in a lot of efficiencies, but at the same time, particularly in the context of platform markets, there can be conflicts of interest, therefore the question of neutrality, and also the ability to leverage market power. Yes. So these, and also it gets very amplified in case of digital markets due to excess of data and direct and indirect effects. Yes. And as ecosystems are developing with a lot of products and services developing around these systems. So that's why these vertical arrangements have to be appreciated, keeping in mind all these aspects.
So that's the approach from the CCI.
Absolutely, but having said that, we definitely keep into mind the efficiencies which these arrangements can bring on the table.
Right, and as we come to the close of the discussion and throw the floor open for any questions that the audience may have, but from the industry side, any suggestions, anything that is not discussed needs to be looked into by the CCI, Sanjeev?
Well, I mean, just brainstorming. I think the fact that we're having a conversation is great. The more we have a conversation, the more we industry learn. Because as Suraj said, look, it's not top of mind. You know, when we are doing stuff, you know, in the company, we rarely apply a competition law filter, right? We look at IP, we look at data, we look at all other laws. But competition is, you know, is afterwards. right? So I think greater awareness in industry about competition law, so that people will take proactive stuff which is compliant with the law. So even inside companies, so I think this kind of interaction is good, maybe further interaction, maybe, I don't know, although this might reduce his billing, but, competition law for dummies, right? Where people get to know that, listen, ye karo, ye mat karo, and on your own, then, you do stuff.
So more awareness and...
well, okay, so CCI may have done that, but I haven't seen it, okay? Maybe that's my fault, okay?
Yes.
Okay, so also, this is a wild thought, and maybe a stupid idea, you may shoot it down. But look, in income tax, you have this concept of an advance ruling. I do not know if in competition law something like that can work. कि पहले आजा हम ये कर रहे हैं, ठीक है कि नहीं?
Ma'am, you want to take that?
So, this issue of advance rulings, of course,
yes,
it's coming from time to time. But the difficulty with that is that the issues tend to be very, very case specific. So it becomes very difficult to give in advance any ruling. But having said that, I would again like to emphasize that CCI believes in a very trust-based regime, even on the enforcement side. For instance, there have been many cases when during the inquiry process, the parties came forward, they said that we were not aware and we've now understood the concern, and they offer to correct it. So that is duly recognized and due regard is given while deciding. And in many cases then there may be, even while imposing penalties, this is a huge consideration because ultimately the objective is market correction.
Yes.
And to work along with industry, and the proposal for settlement and commitments which have been recommended by CLRC are also in this direction. And even our confidentiality regime, which Dr. K.D. Singh and Mr. Manu had explained, are a step in the direction of establishing a trust-based regime. Right. And your point is well taken. I think we will invest even more in terms of reaching out to the senior level of the industry.
That's right. And Suraj, finally, you have any more suggestion? Because from the entire discussion, one thing has come out very clearly, that the definition of the market needs to be understood, first of all, very well, to understand whether it's in line with the CCI regulations or not. And that's where at least from my perspective, I understand that there are a lot of gray areas and a lot needs to be understood. And there will be a lot of legal technicalities on which both the sides will have to work, both industry as well as the regulators. Suraj, any thoughts from your side, from the demand-led side of market definition?
Sorry, yeah. Not on the definition per se. I think definition is something that is important as we think about implementing antitrust practices. But again, in addition to the awareness part that I was talking about, I think what we need to understand is while CCI takes a very trust-based approach, most industry participants also do not want to engage in things that are anti-competitive, as long as they know about what it is, right? And so hence awareness becomes the most critical, I think, pillar in ensuring that there are fewer cases of reducing competition in the market, which ultimately hurt the customer. Right? And I think having these kind of open houses where industry is invited, or letting somebody like a FICCI or a CII conduct these sessions, where you have a lot of industry participation, where they're educated and understand a lot more about this. Honestly, I'm being very honest that I only got to know about all of this in the last 1 week since I was invited here, because our interaction with the CCI has only been to the extent of combinations, because that's what we've been, we've been faced with.
So Suraj, I have myself been involved with CCI, who have reached out to industry bodies and made them explain the entire ethos of the regulator and the policies on which CCI is totally formed over the last many years. So that understanding is now deep-rooted, and I can safely say that the biggest M&A in the country in the cement sector was went in the way it went based on one aspect, CCI, whether it will approve of one player really buying out that asset or not. And that was the biggest defining factor of that biggest M&A that took place recently. So that is, I think, a big enough example of how important CCI has become. But very little time. I know everybody is getting impatient for lunch, but we can take a few questions, please. One mic.
Could you let the mic reach you?
Can you introduce yourself?
I'm Dr. Atul Verma, and of course this was a session on issues and enforcement. Very heartening to know as a stakeholder that the Commission has been instrumental, has had a role in digital revolution and creation of unicorns. Certain issues in enforcement, and I think the youngest panelist probably touched upon, is the delay. The disclaimer, I'm not a person from any legal kind of background, but we have, compared to other laws in the country, I mean, you can get a death sentence through a legal process, through a judicial pronouncement, with only one opportunity for natural justice, which is the opportunity given to the person to defend.
What is the question, sir?
So my question is that one of the issues, the issue is delay, and one of the reasons for delay is that there are 3 levels at which what you call the opposite party, and which is the defendant, gets opportunity to rebut the allegation against him. Usually in any other law, this is only one stage. The other thing that comes to my mind is that the stay given by courts, and we are all stakeholders here, and we would all like the process to be speeded up so that the market intervention is faster. The stays given by court, there is a Supreme Court judgment which says that it should not go beyond 6 months.
For the benefit of everybody, if you can just give the pointed question that you have for the panelists.
So the first thing is that do we need 3 levels of natural justice, which I've already mentioned?
Yes.
Or should we have 1 level like any other law? The second thing is there a mechanism for stakeholders to cut down on stays, especially informal stays, proper stays, despite a Supreme Court judgment of stays not existing beyond 6 months? I think these two should be.
Thank you.
Thank you, ma'am.
I think the chairperson wants to raise an issue.
Just one clarification. I think there was some debate which side CCI should err. And then somebody said it should err on the right side. And the debate was, what is the right side? So it can be wrong side for some other person also. So I think in CCI we try to err on the side of innovation. Whenever in doubt, are on the side of innovation. Are on the side of the entity which is penetrating the market. Because we do not know the path right now. We can't block it. That's what I want to clarify.
Thank you so much, sir.
Ma'am.
Yes.
I am Dr. Rahul Kumar. My question is to Dr. Rajat Kathuria ji.
Yes.
We are talking about competition and domination. Since he is in the education sector, so my question will be to him only. Today, we are noticing that education sector is being dominated by private universities. There is no competition between government universities and private universities. In that case, it is some kind of dangerous trend for a country like us, where 60 to 70% marginalized section of the people live, and they are not able to pay the heavy fees. So my question to Dr. Rajat is, what are his suggestions to the Competition Commission of India to prevent such kind of domination of private universities so that everyone gets chance for the education? Thank you so much.
Thank you so much. Very interesting question. Dr. Rajat, you want to take that very quickly before we wind down?
I don't think there can be a quick answer to this question. It's a loaded question. and there are several aspects to it. If you start by the traditional definition of education being a merit good and a public good and a merit good, countries like Australia have said that only public sector will be involved in education. Countries like the United States allow both private and public sector.
Sorry, sir, please talk about India only.
Yes, I'm coming to India.
We are not sitting in Australia or USA. Right. I have been to 14th country of the world. No, so please talk about India
please,
so that
please permit the panelists to respond.
Sorry for interruption.
Okay, sir, it goes without saying that for a country like India with our large population,
so I don't think
we do need the government to step in.
I was patient enough to listen to your question, and Dr. Verma, if you could be patient enough to listen to my answer. I started by saying that we will be sitting here until the end of the day or probably the week discussing your question. It's a very important question. Education is a merit good. Different countries have responded differently to that merit good. How should we respond in India is the point that I was making. India took on, the public sector took on the role of education, higher education. Schools, primary education was always in private sector hands. There were government schools as well. I think the way forward in India will be a combination of public and private sector. You will not be able to wish the private sector away. Whether the Competition Commission will intervene, should intervene in the fees, whether the fees charged is predatory in nature, whether it is unjustified, those are issues that may come up. I don't know whether they will come up or not. I don't think they should come up. But if they do, certainly Competition Commission will get involved in it. But the pricing of education, if that's what your question refers to, has an inextricable link to quality. And if you want quality education, if you want India to become the hub of higher education, which our government wants, then I think if you start getting involved in fixing fees, etc., it will not happen that way. Does the government have a right over these institutions to be able to regulate? Yes, there is a University Grants Commission that regulates curriculum, that regulates, there are guidelines. There is an Institute of Eminence, which we are going to become, Shiv Nadar University, that regulates the curriculum, but they do not regulate the fee structure. How do you provide access to everybody? Well, there is a 20% scholarship within Shiv Nadar University that is given to needy and meritorious students. You will be happy to know that the Shiv Nadar, and don't want, because you asked this question, I'm going on about this, I'm happy to talk about this with you privately. Shiv Nadar University has the possibility that you could go to what is called a Vidyagyan institution, which competes with the Sarvodaya Vidyalayas. And from Vidyagyan, you come into Shiv Nadar without any fees charged. The question, give me a minute, the question about public institutions and private emergence of private education institutions is a topic that excites me a lot. Have public institutions like Jawaharlal Nehru University, Delhi University, and the great public universities in India, have they seen a decline of their heyday? If there is a decline, what is the reason for that decline? Are there vested interests in the decline of public education in India? How do we revive public education in India? Will the national education policy be sufficient to resurrect public education in India? These are questions that cannot be answered, Dr. Verma, in 2 minutes on a panel discussion, which is not related to the topic. But your question is still valid, that should CCI be intervening in education, in pricing? I think that's a valid question.
All right.
And
Thank you. Thank you so much for the answer. And the final
Can
question
I have
from
one
the
question?
speaker.
Yeah, this is for Mr. Ranji Srinivasan. Sir, you mentioned an emphatic case for boosting industrial innovation. I'm Anusha Khurana, by the way. I was supposed to introduce myself, Additional Director General. You made an emphatic case for boosting industrial innovation, which we clarified that we are definitely on the side of. Now, conversely, you talked of data boosting, data collection, and utilization. My question to you is, isn't that contradictory?
I'm not sure that I understand the question, but are you saying that innovation, of course, is the hallmark of any market development? So if you have innovation, you will have progress in the market. There will be competition. So
Absolutely.
competition comes because somebody is innovating. He says, I'm better than you,
Right.
therefore I'm innovating. So take my product and buy my product. And therefore that happens. So therefore that innovation must always be allowed to flourish if the market has to grow.
What if data collection is being subjudicated in the guise of innovation? That's what my question is.
So when you're saying subjudicated means
Disguised. Let's use a better word, disguised.
I still don't think that I quite
Let
follow
me
the question.
clarify.
Yeah.
On the one hand, we say that industrial innovation is a must. And CCI has already clarified that we are on the side of industrial innovation, which we have proven through our conduct. Now, conversely, we talked of data collection, and we said that when you collect data, you would be doing that in the guise of getting more innovation and saying that you are doing it for the benefit of the consumer. Now, aren't these two steps contradictory? That's what my question is.
I don't think, I may have been mistaken, you may have mistaken me, but I don't think that I said that anybody has a right to withhold data. On the contrary, I said data is power, and therefore don't abuse it. And therefore, if you are going to be the only platform that is available, and you are going to use that for your own benefit and do self-preferencing, for example, and then you go ahead and say that I'm going to have pre-installations, nobody else will be allowed to install, and therefore you will have to operate only through my device or my app, for example. Or you have clauses which say take it or leave it, and therefore the consumer has no choice. And then having trapped the consumer in your device through one app, and you have every transaction flowing only through that app, you do not allow a competitor to access the consumer directly. Yes. So all the preferences, the usage, the habits of the consumer reside in you. And when you do all of that and you have this data power, and then you start, like Sanjeev mentioned, so your own cloud kitchen, for example, or then there is a conflict. You abuse the use of the power, deny access to another person. That could be a cause of concern. So I think that was the point that I was making.
Yeah, now we concur.
All right, thank you so much. And many debates and many talking points. It only shows that it was a successful panel discussion, and we all are enriched with this discussion. Thank you so much to a very active participation by our audience as well. And thank you to each of the participants for sharing your insights and your expert take on this subject. Thank you so much, and have a good day.
Thank you. On my part, I am really personally grateful to all the panelists for raising some very, very incisive issues in the discussion today. It's been a very enriching discussion. My compliments to Nisha for steering this beautifully. It's through a very complex gamut of issues. I found it difficult to keep pace with the number of interesting content and issues that were coming up. So we have discussed a number of things, and the things that emerged and things that we are probably agreed on is that changes in technology have brought positives for consumers, but they've also raised competition concerns. Procedural issues have been raised today by the panel, and it is important for us to continue to address them, even as we are addressing many of them through trust-based resolutions such as our recent confidentiality regime. The very important aspect of economic power of data and its exclusionary and exploitative effects was discussed. We also discussed how platforms with vertical integration are definitely going to continue to come up and are definitely going to proliferate, but they do bring efficiencies for the economy, for the consumer, but there has to be ways for them to ensure a level playing field. There was this very important issue of how, as a regulator, we should continue to make sure that we look at the specificities of our country and guard against colonization of through standards. And the very important aspect of going forward, how it is very important to build collaboration with all stakeholders, including other regulatory bodies that are going to come up in the ecosystem of the country, and the interface that will need to happen, and how our Act already permits and allows that. And the collaboration with stakeholders and industry and a trust-building system. We've taken note of all the issues that have been raised here, and we'll really think about it. And I especially take note of the fact that we probably need to have a lot more conversations of this nature with industry to address the issues raised by Mr. Saharan and Mr. Bhikchandani, that they need a lot more awareness. So going forward, we look forward to a lot more conversations on these issues, and I hope that today's discussion will lead to a lot more thinking and wider debate and discussion on the issues that have come up today so that we can come up with solutions. I think Chairman said it very well when he said that our basic philosophy as the Competition Commission of India is to err on the side of innovation. With that, I would also like to thank the audience for being with us through this 2-hour-long session. Thank you very much, everybody.
Ladies and gentlemen, please give a big round of applause to our panelists for a very intense and interesting session. May I request Dr. Sangeeta Verma, member CCI, to thank our panelists, presenting small tokens of appreciation.
Certainly, certainly.
Request Dr. Sangeeta Verma to thank Mr. Ramji Srinivasan, Senior Advocate, Supreme Court of India. Request ma'am to thank Mr. Manu Chaturvedi, Advocate, Delhi High Court. Mr. Sanjeev Bhikchandani, Founder and Executive Chairman, InfoEdge. Mr. Suraj Saharan, Co-Founder, Delivery. Dr. Rajat Kathuria, Dean, Shiv Nadar University. Ms. Nisha Podar, Editor, CNBC TV 18.